Paying taxes are a part of everyday life, but a U.S. law called the Foreign Account Tax Compliance Act, or FACTA, is clamping down on tax evaders. The statute was passed in 2010, and one new requirement is the reporting of foreign assets on a new form if you have more than $50,000 of foreign assets. U.S. taxpayers were already required to report their assets to the Internal Revenue Service, but now FATCA is holding financial institutions accountable for providing the information about their American clients. FATCA will likely help the U.S. Treasury collect another $800 million in taxes per year, but reports put the cost of implementing the law between hundreds of millions to over $10 billion for those foreign institutions. It's not just U.S. citizens impacted. Green card holders, students, people working overseas, and certain investors will all have the need to declare their assets. Attorney Michel of Caplin and Drysdale advises clients on taxes, and I asked him what could happen to those who don't comply.
Non-U.S. persons who may have invested in an American asset at the financial institution are the ones at risk if the financial institution does not comply with this new regime.
Okay, let me perhaps step back a little ways. Why was this put in place a few years ago? Was it because of money laundering? Was it because people weren't reporting the taxes they owed? Was it tax evasion? All these things go through my mind.
Right.
What was the tipping point?
It was tax evasion. Beginning in about 2008, the IRS and the Justice Department began to investigate UBS. That cascaded into a series of other investigations. The IRS adopted an extensive voluntary disclosure program, and Congress decided to get into this enforcement template and implement this extraordinary extraterritorial automatic information exchange regime. But it is designed to require the reporting of accounts for tax purposes.
Okay, it sounds like on the surface you're asking basically U.S. citizens who have assets abroad who may or may not have reported those assets to report them now to the IRS. It doesn't seem like there's anything wrong with that. It seems quite an honest and harmless act, if you will. What's the cost and what is wrong with it?
Well, Americans have been required to report their foreign assets in any number of ways for decades. The difference here is that this is an obligation that now falls upon banks and trust companies and fiduciaries and certain other entities that have been swept into the statute. And those entities, whether or not they have a physical presence in the United States, are required to comply with this rule, required to provide information to the IRS, or face a 30% withholding sanction on their American assets.
What if the bank doesn't know you're a U.S. citizen? I mean, in all honesty, this happens a lot. You have a foreign person who may have dual citizenship. They open an account at a UBS or at a Credit Suisse. They didn't tell the banker that. The banker doesn't know. Is the bank on the hook here?
Well, the regulations recognize that no system is foolproof. And so what they set out are a series of indicia that banks are required to look for to determine whether or not an account holder or someone affiliated with the account might be an American. So it could be as simple, of course, as a copy of a U.S. passport, but it could also be things like instructions to transfer money to the United States.
Who are they really? Who is the government or the IRS in this case? Who are they really going after? I highly doubt they're going after mom and pa and sort of the small accounts. There must be some big accounts that aren't paying taxes that this particular act is focused on.
I think that's right. I mean, a lot of people with large accounts have already come forward and made voluntary disclosure about their foreign assets, but there's clearly a perception that there are large numbers of American taxpayers who have not yet done that. Unfortunately, a lot of the mom and pops are getting caught up in this. Students abroad, people who work abroad are having a hard time opening a bank account.
Well, that brings up a really good point. There are students and there are people from Asia, China, Europe, you name it, who have the green card. So technically, with the green card, you have to pay U.S. taxes.
Correct.
They may have assets elsewhere. Are they expected to report all of their family holdings because they have this green card?
Yes, they are. They are required to file U.S. tax returns just as if they were a U.S. citizen living in the United States. Now,
what's the penalty if they don't?
It could be a criminal offense if they act willfully.
They could go to jail, is what you're saying.
They could theoretically go to jail. Now, whether or not that's going to happen to a long-time non-resident, one can only guess. But where a green card holder does not file U.S. tax returns, does not file information returns, does not file foreign bank account reports, willfully, that can be a criminal offense. It can subject them to significant civil penalties, even if it's not a criminal offense. The IRS can come after them for back taxes.
That sounds like a lot of paperwork. Scott Michel, tax partner at Caplin and Drysdale, thank you very much. Next